Welcome and thank you for joining Seyfarth's webinar, Asia Pacific Reductions in Force, 10 Things to Look Out For. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. At this time, I'd like to turn the program over to Jana Komsitsky. Jana, you may begin.
Thanks, Sophia. Welcome, everyone, to the APAC-focused episode of our webinar series on conducting global reductions in force. We'll refer to these as RIFs and sometimes redundancies. My name is Jana Komsitsky, and I'm Senior Counsel in the International Employment Group at Seyfarth Shaw in Los Angeles. But I'm delighted to introduce my esteemed colleagues from the APAC region. Catherine Weaver, based in Hong Kong, Leon Mao, based in Shanghai, and Rachel Bernasconi, based in Sydney, all of whom I'm privileged to collaborate with on global reductions in force and other global employment projects. The agenda for today will cover planning and strategy timing, the rationale for restructure, selections and redeployment, consultation, severance costs and benefits, timing challenges, logistics and practical implementation, considerations for expats, and some post-employment considerations, as well as associated risks.
Jana? Well, the first thing then to think about when contemplating an APAC-wide reduction in force is planning. Planning. Proper time spent on overall big picture planning and strategizing at the start can really help you avoid some costly and time-consuming issues at a later stage. The key question we ask when instructed on a reduction in force exercise is how can we help the client achieve its business objectives in the most efficient and effective way whilst also avoiding legal and cultural pitfalls? And conducting RIFs in Asia Pacific can be particularly challenging because of the huge variety of legal requirements and local nuances, and they vary greatly between the different jurisdictions in Asia Pacific. So how can we ensure that the RIF is carried out in a coherent and synchronized manner? Well, first, it's crucial to understand the legal requirements of the jurisdictions in which the redundancies are going to be made. In Asia Pacific, the legal framework for RIFs can be quite different depending on whether the country is employer friendly or employee friendly. And what we've done is we've set out on the slide here a basic heat map showing which jurisdictions, in our view, have the most challenging statutory rules around carrying out redundancies, and they're the ones shown in red. In amber, we've got the moderately difficult but workable jurisdictions, and those marked in green are relatively straightforward jurisdictions. And the coding, by the way, is based on collective redundancy laws in each jurisdiction where they have them, rather than the laws related to individual redundancies. So starting with the green category, we've got Hong Kong and Singapore in there where RIFs can be carried out quite easily. In Hong Kong, there's no collective redundancy laws and there's no set process for carrying out a redundancy either. So you can dismiss an employee for pretty promptly when it comes to doing redundancies, as long as you pay them what they're entitled to under contract and statute, as long as you don't select them on discriminatory grounds, and as long as they don't fall within a protected class. And similarly in Singapore, there's relatively little law governing how redundancies should be conducted, but of course employers should bear in mind the tripartite advisory on managing excess manpower and responsible retrenchment, which does set out some pretty clear guidelines on what employers should consider in a redundancy situation. In the amber category, we've got Australia, India, Malaysia, and mainland China. And amber meaning here that employers need to go through some more legally prescribed steps to carry out reductions in force than they would have to do in the green jurisdictions. So, for example, in Australia, for some employees who have access to unfair dismissal, employers are required to consult with those employees and consider redeployment options. In the red category, we've got Indonesia, Japan, South Korea, Vietnam, and Taiwan. And these are the jurisdictions where carrying out redundancies under the statutory rules can be quite tricky. For example, in Indonesia, a prior court order is usually required to terminate an employee's employment, and a formal process which has various steps has to be carried out in order to obtain that court order. And in Taiwan, where the reduction in force constitutes a mass redundancy, employers need to follow specific procedures, including proposing a redundancy plan to the local labour authority and the affected staff at least 60 days before the proposed termination date. So the legal requirements for each jurisdiction may affect the overall planning and strategy for implementing redundancies in Asia Pacific, and might also, probably will also affect budgeting and communication plans. And I'll talk a bit about that in the next slide. But just, I wanted to make one point before we move on to that next slide, and it's an important one, which is that whilst it's really important to understand the legal framework affecting redundancies in the jurisdictions in which you're going to be making cuts, in practice, most companies prefer to deal with a RIF by way of mutual separation agreements. In other words, you'll be offering the employees an ex gratia payment in return for them waiving their rights to bring claims against the company. And by following the mutual separation route, companies can often avoid having to deal with all the statutory rules and regulations for RIFs across APAC. But of course, there's always the risk of an employee refusing to sign the agreement and the company having to commence a statutory RIF process in any event. Next slide, please. So on this slide, we've set out the other key considerations in relation to planning and strategy timing. We've already covered legal requirements, so we've just been through the importance of that and understanding how, why they're necessary to understand about when you're conducting a RIF. One additional point I wanted to bring out in relation to that is that it's important to gather all your information that you need up front so you can carry out a proper assessment of what legal requirements are applicable or triggered. So in addition to kind of basic information around employee lists and headcounts and salary data, length of service, etc., there might be some specific information that companies are going to need to collect. For example, local to foreign employee ratios for Malaysia and Singapore, annual leave records for Hong Kong, or trade and labour union details for China and Taiwan, etc. And by understanding what information you need and collating it at the beginning of the RIF, that can help you ensure that the process runs smoothly and that hiccups are avoided later on. Timing, so we're on the second point now. So often businesses will have an intended timeline for completion of the APAC RIFs. For example, they want to get it done by the end of the financial year, or before or after the completion of an M&A project. And sometimes these timelines are realistic and achievable, and other times they're not. But if it's imperative to you, your company, that the RIF has to take place by a particular date, that's likely to affect the way in which you conduct the RIF. You're most likely to take the mutual separation agreement route in a scenario where timing is everything. It has to be done quickly because it's going to be a quicker route. But if, for example, cost is your main driver, you're more likely to want to consider the statutory route because that's going to be cheaper, but of course, it's likely to take longer. So it all affects the kind of timing considerations. It's useful to start with the intended date for completion and then count backwards or work backwards to make sure you can complete all the necessary legal steps in each jurisdiction in time. And if you can't, then you might need to reconsider your completion date or revising the process accordingly. And it's also important to ensure that the business case that you have is mature at the time of the proposed RIFs. There are substantial risks in starting the RIF process too early on potentially shaky grounds, not only litigation risks, which might involve criminal consequences, but also PR and reputational risks. And another major timing consideration is when to announce your RIF to staff. And I know Jana is going to be talking about that later on and some of the other timing challenges. So I'll leave that point there. Although it does actually come into the next point around communication too. So on to 3, communication. As mentioned, the overall timing will also impact the communication plan. If you need to stagger the timing of your RIFs in different jurisdictions, how do you communicate that to the workforce and manage their expectations? Do you announce the redundancies to all employees in Asia Pacific at the same time by way of a town hall, for example, or is it better to go country by country? Now, there's no right answer to that, and it often depends on the circumstances of the RIF, how the company prefers to communicate and operate, how stable the workforce is, etc. Things can get quite complicated quite quickly when you're devising your comms plan because lots of questions will arise, such as, Can you make an announcement when a court order approving the RIF is pending? Can you make an announcement directly to employees if there are obligations to first consult and inform trade unions, in China, for example? All of this is to say that communication and messaging is absolutely critical, and a one-size-fits-all approach across Asia Pacific may not work, probably won't work. It's also important to make sure that your communication is clear and effective, and having a clear communication plan up front can really help manage expectations effectively throughout the entire RIF process. More on this point from Rachel later on. On point 4, we've got costs and budgeting. Now, there's various elements to the costs and budgeting stage. First, you need to understand and calculate the costs in each jurisdiction related to the affected employee statutory and contractual entitlements on redundancy. So we're talking about things like statutory severance pay, payment in lieu of notice, pro rata bonus. So you need to gather that information and calculate how much that's going to cost. And then you need to think about whether you wish to offer an enhanced redundancy package to the employees, and if so, the basis on which you're going to be calculating that. And I know Leon's going to be talking about that a bit later on as well. Third, in the budgeting and costs category, you might want to think about a contingency fund for any litigation that arises from the RIF exercise. Hopefully nothing will, but you never know. And fourth, of course, legal fees. These can't be forgotten. You need to factor those in, and because you need to manage those too. And so, if you have all those costs together, then you can set your budget, and it'll help you inform what that budget will be for the whole project. And once it's set, then of course you need to continue to monitor it and monitor the costs against it, and make sure it's all progressing according to plan. Number 5, we've got business case and objectives. So finally, we're going to talk about this element. This can be crucial, really, having your business case and your objectives. In many jurisdictions, there needs to be a proper business case in order to implement redundancies, and it might have to fall within the specific definition of what a redundancy or a retrenchment or a reduction in force is in a particular country. Leon's going to go through business cases in more detail in the next section. When it comes to business objectives, this will often have an impact on how roles and employees are selected for redundancy. So, for example, the roles to be eliminated will usually be those that no longer align with the company's objectives. And the employees selected for redundancy will often be those who lack the skills, experience, and competencies the business is looking for to drive the business forward going in the future. So it's important also to try and avoid disrupting the business as much as possible during a RIF exercise. Companies want to plan and strategize in a way that maximizes and continues employee engagement pre and post RIFs, and also minimizes risks to the company, including litigation and reputational risks. So the key takeaway here is not to look at all these planning points in a vacuum, but to understand the whole landscape in which the risks will happen and to plan accordingly. I'm now going to pass over the time to Leon to discuss the business case and rationale for restructuring.
Thank you, Kat. Picking up your last point about business rationale, I think, companies should make sure there's a proper business case for RIFs. It's also important to ensure that the business case falls within the permitted grounds for RIFs in each specific jurisdiction. The permitted grounds differ. In some jurisdictions, a genuine business case for RIFs would suffice. In other jurisdictions, the business case may need to align with specific permitted grounds under labor law. So further, in some jurisdictions, there may be no need to justify the reasons behind the RIFs, while in others, employers may need to provide adequate explanations or even show proof supporting the decision. Let's look at some jurisdictions as example. In Hong Kong and Singapore, no legal requirement to justify to employees the reasons behind the decision. It is sufficient so long as companies have genuine business rationale for the RIF. In Australia, objective business-related criteria is recommended to reduce legal risk. In India, similarly, objective business-related criteria is required, and companies need to provide reasons of the RIF to employees. In Japan, South Korea, Taiwan, and the PRC, specific grounds criteria are required by law, and companies may need to required to provide proof. In South Korea, RIFs must be based on urgent business need, such as financial distress with continued financial hardship going forward, unless the layoff is implemented. In addition to other requirements for RIFs under the Labor Standard Act. In Japan, business necessity of employer to carry out a compulsory RIF is a legally justifiable reason for termination of employment. To this end, if the RIF is challenged, an employer will need to justify the business necessity. For example, the necessity to reduce a workforce, efforts to avoid dismissal, reasonableness of standards, and the selection of employees subject to dismissal, due process of explanation or negotiation with employees or labor unions. In Taiwan, companies can only carry out RIFs under specific permitted grounds, for example, stoppage of business or transfer of ownership, business losses, or curtailment of business operations, alteration of business leading to a reduction in the number of employees, where they cannot be reassigned to other suitable positions. The justification for the RIF needs to be explained in a plan which will be filed with local labor authority and shared with employees if a mass redundancy is triggered under law. In mainland China, laws have developed to some extent to address what would generally be termed as a redundancy termination under any of the following scenarios. The employee is restructuring based on bankruptcy, or the employer is restructuring based on bankruptcy, or the employer is suffering serious difficulties in its business operations, or the employer has amended labor contracts as a result of switching business modes and still needs to reduce its workforce, or the employer can prove a major change to the economic circumstances. That's a brief of rationale for the RIF. Thanks. Next slide. Thank you.
Thanks, Leon. Now we're going to talk about the selection of employees, determining which roles or employees are going to be selected for redundancies. And on the slide, we've provided on the next slide, a framework for covering off the key considerations to ensure you get it right in each jurisdiction where redundancies are likely to occur. So the first thing, and these aren't in any particular order, but the first thing to be aware of is, as Kat has mentioned, in a number of jurisdictions, there are legislative prohibitions on terminating an employee due to redundancy where that employee has a particular protected characteristic. Some of the key characteristics to be mindful of include things like pregnancy, maternity leave, absence due to work-related illness or injury, or being an employee representative. So in jurisdictions such as China, Vietnam, Korea, Taiwan, Japan, and Hong Kong, the presence of that prescribed attribute may provide an absolute protection for the employee, or at the very least make terminations far more difficult, even if the attribute is not the reason for selection for redundancy. So in those jurisdictions, you need to be very careful, and you may in fact need to ring fence, say, pregnant employees or those on maternity leave or have a particular protected characteristic from the RIF. In other jurisdictions such as Australia or Singapore, so long as the reason for selecting an employee for redundancy is not because of or doesn't include that protected attribute, then there's no absolute protection merely by holding that attribute. Again, as we know, care needs to be taken though, because we need to reduce the risk of discrimination claims, and you might need to pressure test your reasoning to ensure that there in fact is no underlying discriminatory reason or unconscious bias in the selection process. The second thing you need to check is whether there are statutory criteria which need to be applied when selecting employees for redundancy in an affected jurisdiction. So statutory criteria exist in jurisdictions such as Malaysia and PRC, where last in, first off, or first out may need to be applied. And some jurisdictions have particular selection criteria when expats are in the mix, for example, Malaysia, and Kat's going to touch on this issue in a bit more detail shortly. Even where there are no mandatory statutory criteria, there may be other instruments that need to be considered, and they may contain restrictions on who is selected and what process should be applied. For example, in Australia, many collective agreements specify selection criteria or mandate, for example, expression of interest processes to be undertaken before moving to compulsory retrenchment. In Singapore, as Kat has mentioned, there are guidelines in place which regard needs to be had to. They state that employers should take a long-term view of their manpower needs in a retrenchment exercise, including the need to maintain a strong Singaporean core. Again, even in jurisdictions where the statutory criteria are not mandated, you may still need to defend selection decisions down the track. So in places like Australia, Singapore, Hong Kong, Japan, where, as Kat's mentioned, it's a little bit more straightforward, we still recommend, generally speaking, that objective and non-discriminatory criteria are applied in selection decisions. These are things such as skills, qualifications, licenses, experience. And this is particularly so where downsizing within a group of interchangeable roles. This is going to help in defending against claims that the selection was for a discriminatory reason or was otherwise unfair or unjustified. And Leon is going to talk about some of those risks a little later. Next slide, please. This is just a little ready reckoner summarising the key jurisdictions. On the left, where there are no statutory criteria. In the middle, where there are statutory criteria that may apply. And on the right, the jurisdictions where you particularly need to consider the issue I mentioned before about possibly needing to ring-fence particular employees who fall into protected categories. Next slide, please. The next issue to turn your mind to is whether in the affected jurisdictions there's an obligation to consider redeployment to vacant positions within the company or the group, either locally or worldwide, to try to avoid redundancy terminations before proceeding with compulsory redundancies. In Australia, for employees who earn under the unfair dismissal threshold, redeployment within the group needs to be considered prior to termination. Otherwise, the termination may not be regarded as a genuine redundancy and may be challenged as an unfair dismissal. In Japan, although redeployment is not a specific legal obligation, nonetheless, employers are expected generally and by the court to only proceed with a RIF if, amongst other things, it was necessary and after every reasonable effort was made to avoid the redundancy. So this is going to include considering the option of redeploying the employees prior to termination. The other thing to be aware of is that in Malaysia and PRC, employees who are made redundant should, as far as possible, be given priority for re-engagement if the employer subsequently starts rehiring employees in those affected categories. Next slide, please. Turning now to consultation. Whether or not consultation is required, as Kat's mentioned, varies between jurisdictions. And this needs to be factored into your timing and process, and Jana's going to touch on some of this shortly. Just to touch on a few examples where consultation needs to be particularly considered. So in China, Vietnam, and South Korea, employee representative or union consultation is mandatory. In Australia, union consultation may be required, and this is the case in Japan as well, if employees are union members and seek assistance from the union. In Australia, consultation with affected employees and or their unions about proposed redundancies is also going to be required where a modern award or a collective agreement applies, as well as where 15 or more redundancies are likely. It's usually the case that the consultation process can be fairly streamlined though, so it shouldn't, in those jurisdictions, unreasonably delay implementation. In Malaysia, consultation is not mandatory, but it's recommended under the code. In terms of timing, Kat's touched on this, but other considerations need to be taken into account. So for example, in PRC, the consultation process needs to be kicked off 30 days before any dismissal. And in South Korea, 50 days prior notice of a RIF needs to be given. In Japan and Vietnam, certain documents need to be in place before proceeding with the RIF, which again impacts on the timing. All of these things need to be built into the process and the timing. The final point to be made here is that in some jurisdictions, including Australia, relevant information may need to be handed over to either employees and unions about, say, the economic rationale for the RIF, the selection criteria and the basis for abolishing certain roles, that kind of information. So going back to Kat's point, it is important that that work is done in advance to make sure that if and when you are sitting in front of an employee or a union to explain this, that all of that thinking has been done. The final point to make is that always remember that litigation is a possibility in many of these jurisdictions. And so any internal documents and correspondence floating around between internal stakeholders might be discovered. So always take care. Next slide, thanks.
Thanks, Rachel. Understanding the budgeting impact can help avoid going over budget. Also, costs and the budgeting concerns would affect the overall approach to the RIF. Below are some common costs involved. First is statutory severance payment. Set out on the slide are the formula for statutory, severance in some APAC jurisdictions. Notice period or payment in lieu of notice will normally be provided in cases other than employees' misconduct. Bonus and RSUs would normally be subject to contractual arrangements. In some regions, outplacement services will be provided to the impacted employees. Other costs may include those incurred by threatened or actual litigation. For example, use of HR or business time or resources or legal fees. In addition, there may be PR risks, which would lead to HR or PR colleagues' time and resources and the potential PR consultancy firm fees. Further, employers can consider whether or not to offer an enhanced severance. In many jurisdictions, employers can enter into separation agreements with employees by offering an enhanced package in exchange for a release of claims from employees. A mutual separation may cost more, but the decision to take this approach may be impacted by a number of factors, including the strength of the business case, the need to mitigate litigation risks, etc. Further, in some jurisdictions, such as Japan, it may be the market norm to offer an enhanced package to employees. And there may be market benchmarks. Therefore, apart from looking at the legal requirements, market practice and the expectations may also affect the costs and the budgeting of the RIF. Set out on the slide are some common enhanced severance package that we've observed in some jurisdictions. In addition to the, costs we mentioned before, If impacted employees refuse the mutual separation, employers need to prepare the Plan B on a case-by-case basis. And further, employees may raise other claims such as discrimination, privacy, or breach of contract during a RIF. And that's a brief of the severance costs and benefits during a RIF. Thank you. Next slide.
Thanks, Leon. Timing challenges. It's important to consider appropriate timing of communications, including any global announcement of any plans to conduct RIFs, and equally commitments to any timeline for finishing these exercises. Getting the communication plan right is crucial. Announcing unrealistic timing can have an impact on financial results, reporting and RIF costs, allocation, as well as employee morale. We see a tendency sometimes to want to rip off the Band-Aid, as Americans will say, in order for the company to move on with new business or the next phase, especially in the context of busy periods for sales and product delivery or product ship target dates. However, country-specific limitations can cause the RIF completion date that may have already been announced internally or externally, and that's the date that all impacted employees are completely out, to slip because employees are not out, impacting the other operational scheduling. So it's important to make sure you don't jump the gun with any definitive statements made globally or regionally or at the country level, especially concerning around the completion timing. Some countries take significantly less time, of course. We've spoken about Hong Kong and Singapore being, quote, relatively easy jurisdictions, for instance. That doesn't mean that we need to go first in Hong Kong and Singapore. It might mean that we plan accordingly and perhaps save them for last after some of the more difficult locations have been resolved or put into motion. The decision will really be on a company basis. Some of the local matters that can impact timing include the information gathering needed to establish the correct justification, which may be much more time consuming in some countries. For instance, necessitating an economic analysis or expert report. For protected employees, including pregnant and sick employees, it's important to determine how long protection will last and whether additional extensions are possible. And we sometimes find clients are far into a RIF exercise before they realize employees are protected, which employees are protected and for how long. It may be necessary to carry protected employees until their period of protection is over and for some period afterwards. Consultations may need to be at least initiated and sometimes completed before potential impacts may be announced. Third-party employer involvement may mean delays in implementation, sometimes significant ones. While the company notifies the PEO or EOR, which may then need to coordinate with their local service provider or the direct employer, if that is yet another third party. Any services contract with a professional employer organization or employer of record should be consulted for the advance notice required, which will be stacked on top of any notice to the employees most often. But even this timeline may slip if there are any disagreements as to how to proceed with the actual employer of record or PEO managing all your global or regional relationships. Global companies need to look out for local holiday periods as well. We've got the Lunar New Year in February, Golden Week in April, May in Japan, and other days or periods where it would be considered bad form, insensitive, or even impossible to undertake reductions due to government closures, people being on vacation, typical annual leave periods, and the like. This can impact things like getting the legal advice that you need, availability of consultation bodies, presence of employees in the office, and opening and closing times and days of government authorities and agencies. Where negotiations are required for practical purposes, which is practically speaking the most common approach across the board in most locations, it may be necessary to consider the impact of target exit dates and work with the employees accordingly. Common items we see are upcoming long-term incentive and equity vesting dates, requests to work around the school year, allowing kids to finish in school that year, visa-related extension requests, retirement-related requests, and tax-related requests where severance payments create tax consequences depending on the year, the tax year they hit. It's important also to manage precedent-setting issues when negotiating with individual employees to avoid knock-on effect for other employees or other locations even. Next slide, please. Logistical and practical implementation. For a multinational, particularly one based in the US, the logistics and practical implementation matters in the APAC region can pose particular difficulties. For delivering the news, again, consider timing, including time zone differences and who will be available to deliver the news. Practically speaking, Asia either goes first or may have to wake up to news of a RIF from the day before in the US or elsewhere, which can cause some discomfort in actually carrying out the exercise on the day. Determining whether you can have in-person meetings or need to have remote meetings and whether they will be held in a group or individual setting is also important to do ahead of time. We often say in-person meetings are best, but for larger rounds and in cases where there is no HR function or limited HR function on the ground, scheduling can be tricky and there may be technical and logistical difficulties with remote meetings, including things like unreliable internet and lack of printing or scanning facilities for getting documents back and forth, unavailability of couriers. Appropriate representation and powers of attorney. This is one item that should be confirmed early on so that any decisions and terminations are not compromised by invalid or inappropriate or unauthorized representation, including in locations where local national HR people must be making employment-related decisions. I'm thinking of Indonesia there. POAs may be needed to sign related corporate documents, including share transfers and buybacks, and it may be necessary to offer retention packages to your key employees to help work through the logistics. And those are the people that are keeping the lights on until everything gets done. An extension of this point is preparing for collecting signatures. For the company, or signatures for the company, consider where a CHOP is required, including Taiwan, a seal in Hong Kong and China where it's widely accepted to use a seal, and where coordination with the PEO or EOR is required. Because they'll have their own corporate signatory requirements and you'll want to be able to chase those down when you need. For the employee, you'll want to consider how they will sign. If remotely, is a scan going to be sufficient? Do they need to return the original? And how will any required duplicate copies get where they need to be? Also consider if you need witnesses and if those witnesses are available on the day or in the presence of the employee where that person may be, and whether the witness is appropriate. Removal, resignation of directorships may be required from exiting employees, and so consider whether a replacement must be appointed and any nationality or residency requirements associated with that to make sure that you have someone available to step into the shoes of that exiting director. Director shareholder resolutions may be required for forced removal of any directors who are not going willingly as part of their negotiated exit. When collecting company property and equipment, consider how this will be collected and whether it will be shipped all the way back to HQ, wherever that may be, or collected somewhere more regional, or allow, if you're going to be allowing the employees to retain equipment, and what IT procedures will be required before they can do that. That's it for logistics, and now on to considerations for expats from Kat.
Thank you. So, yep, it's back to me on the topic of consideration of expats. Now, we've run this webinar a few times. We did a general global overview, and then we did one for Europe. And in those, we didn't have a specific highlight on expats. But we raise it here because in Asia Pacific, there is a large number of expats. We often find that this group of employees has its own unique issues in a RIF exercise, some of which I'm going to go through in a moment. And if you forget about your expat population, if you have one, in the RIF planning process, that can often lead to missing out on certain specific requirements, which then cause massive hiccups in the RIF timeline. So, and then they could even invalidate the process. So it's worth having a thought to your expat population when you're doing your planning as well. So on this slide, we've set out 4 areas that companies might need to take into account when the RIF involves expat employees. First up, we've got selection criteria. So are there specific selection criteria that apply to foreign employees? And there may be legal requirements in place requiring companies to select foreign employees for redundancy before local employees. For example, in Malaysia, within the same category of workers, foreign employees must be retrenched before local employees. And then you've got to look at the impact on employee composition. So you might have to think about the foreign to local employee ratio of the workforce in certain jurisdictions. And that doesn't necessarily mean that you need to make expats redundant over locals. This is different from the first point we made. It's just that you've got to bear in mind that the composition of the workforce after the RIF exercise must still comply with the foreign to local employee ratios for that jurisdiction. So, for example, the maximum foreign employee to local employee ratio in Indonesia is 1 to 10. And in Malaysia, starting from 2025, companies in the manufacturing sector are required to maintain a ratio of 2 to 8. And to maintain that required ratio, you will need to consider if expats should be included in the list of affected employees, and if so, how many. And it may be the case that you don't need to include any expats in the RIF. You know, for example, if you've got a very large local population and only a handful of expats, then it may be that you don't have to put expats into the mix at all, as long as you're complying with the obligations that you have around foreign to local employee ratios. In some jurisdictions, for example, Vietnam, companies can only recruit expats for positions that require certain skills that can't be found locally. So companies may want to consider whether they can move their expats in a particular jurisdiction to an alternative role, which does require the expat's skill set, if that could then save time and effort recruiting other expats from abroad for these roles in the future. So is there a possibility of moving these individuals around? Also, companies should consider whether any workplace arrangements need to be reviewed in relation to expats. For example, in Indonesia, employers are required to appoint a local employee to be the companion of every expat so that they can exchange technology, know-how and expertise. If a local companion is going to be terminated in the RIF exercise, then the employer is going to need to appoint another local companion for the expat employee. Work visas and permits, this is probably a more obvious point here. So you need to consider the terms of the employee's visa, especially those that are sponsored directly by the employer. Will that work visa lapse following the termination, or will the employee be able to continue to stay in the jurisdiction and try and find another role? In Hong Kong, for example, while the general employment visa needs to be sponsored by the company, if the employee leaves the company through redundancy or for whatever reason before the expiration of the visa, they can stay in Hong Kong to seek alternative roles. They can stay here, and when they get an alternative role, they then have to apply to get the visa transferred over to the new company, but they don't have to leave. If an employment visa is going to lapse following the RIF exercise, then you need to consider as the employer if there's any statutory or contractual obligations to repatriate your expats. So note, for example, in Indonesia, employers do have a positive obligation in respect of expat employees if they carry out specific roles such as director, head of representative office, trustee. In this case, the employer needs to ensure that the appropriate arrangements are put in place to get the expat returned to their home country after the termination of employment. And even if there's no legal obligation on companies to ensure the repatriation of expat employees, you might want to consider whether you want to offer some kind of repatriation package as part of the RIF, and then that could also perhaps form part of the mutual separation agreement with the expat employee. And this will affect your costs and your budgeting, of course, but it could be a good option. For example, if you are wanting your employee to sign up to a mutual separation agreement, for example, if your business case isn't particularly strong. So you can use that as potential consideration. And while we're on the topic of repatriation, I wanted to highlight a few other points that quite often come up when we're dealing with riffing expats. So quite often they'll raise things such as, do I get my flights and my travel reimbursed? What about the subsidies for children's schools, tuition fees? Do I have to leave now? My kids in the middle of a school year. What are you going to do about moving my personal belongings from country A to country B? Can I stay in my accommodation here? It's not going to be filled. The lease is in place. Can I not at least stay until the end of the lease period? Will you buy out my gym and other memberships because they're not going to expire for another year or 2 years? And then I think Jana mentioned this point also earlier. There's quite often a lot of chat around the timing of the payments, the timing of the termination payments, the severance payments, and tax planning in relation to different jurisdictions in which that individual might be tax resident. So if an employer decides that they want to support employee repatriation, then it's quite common to have that already in a repatriation agreement or to then enter a new repatriation agreement. And this could also be appended or added into the mutual separation agreement terms. So that takes us on to our last point on the slide, which is around notification obligations. So when the employee is on a work visa, companies would normally then need to have to notify the relevant authority, usually the immigration department, when that employment is terminated. And there's often a prescribed timeframe in which that notification will need to be made. Notification might also need to be made to the tax authority and or the pension provider, and I can provide a bit more information on that in the next slide. In some cases, authority approval may be required in relation to the termination. So in Indonesia, for example, pre-approval is required in relation to a foreign employee's change of employer, and the approval will only be granted in specific circumstances, including company restructuring and closing of a business. Next slide, please. So yes, another top 10 thing to look out for in a RIF exercise are the post-employment considerations. They're quite often overlooked when you're planning, and this can mean that you end up spending longer on your RIF wrap up than you anticipated. I'll go through a few of them now. So taxation, back onto taxes. So yes, employers might in certain jurisdictions have an obligation to notify tax authorities of the termination of an employee's employment within prescribed timing. In some jurisdictions, the notification might need to be made prior to the termination of employment. And this is the case in Hong Kong, for example, where employers are required to make the notification 1 month before the intended termination date. Also on the tax point, quite often the query will come up as to whether the statutory severance is taxable as income, and different jurisdictions will have different approaches on that, and it's well worth looking into. And then there's a further query of whether enhanced severance payments, i.e. the ex gratia payment, is taxable or not taxable. And again, that will depend on the particular tax authority in the particular jurisdiction. Also, you need to consider whether you as the company have any withholding obligations. In Hong Kong, again, if an employee intends to leave Hong Kong for a month or longer after the termination of employment, the employer will have to notify the tax authority of this and will have to withhold the termination payments until the employee obtains tax clearance from the authority or 1 month passes, whichever is quickest. So it's important to understand all of your tax obligations in different jurisdictions, and that should also go into your planning and your timing. Data retention, just a small point on this. So, but of course, we've been seeing governments in Asia Pacific placing greater emphasis on data privacy and protection in recent years. And in terms of employee data, what we need to do is find out in the different jurisdictions what the rules are on data retention requirements, as well as what is best practice or guidelines in the market. We use Hong Kong as an example again here. So employers are legally required to retain certain employee data for at least 12 months post-employment, but best practice suggests that employers can actually retain that data for up to 7 years, as in just past the limitation period. But of course, if you get a breach of data privacy law, if you get it wrong, then this can lead to some quite serious consequences, both civil and criminal sometimes. pensions. Let's go on to pensions. So there might be some notification requirement in relation to pensions here. Employers might need to inform the pension provider or the central authority if pensions are managed by the government. Then it might need to tell them about the termination of the employees. Consider also if there are requirements, whether they're statutory or contractual, for employers to assist with or procure any transfer or withdrawal of the pension funds. If so, the employer should prepare the necessary paperwork and liaise with the employees and the relevant providers in relation to this. Note also whether there are any prescribed timings for doing this, which might need to be taken into account in the planning. Restrictive covenants. So it's common for employment contracts to provide for post-termination restrictive covenants, for example, non-competes or non-solicitation of employees and customers. And when you're looking at your restraints, there's two things to consider: whether they're enforceable in the jurisdiction, and if so, whether the employer intends to enforce them in a RIF situation. As regards to enforceability, local law advice is going to be recommended in this situation. So the legal frameworks are quite different in different jurisdictions. In Malaysia, for example, restraints are prohibited. In China, they're allowed, but they must be compensated for. In Australia and Hong Kong, restraints can be enforceable, but they've got to be drafted carefully. So even if the restraints are enforceable, employers may or may not want to enforce them. For example, if an employee has been on garden leave prior to the termination and therefore has been out of the market for a while, it may not be seen to be necessary to enforce the restraints. Or you might consider it unfair to enforce restraints when you're making employees redundant because they're being forced into the market at a time not of their choosing. And you may want to give them the best possible chance to find alternative employment quickly. If you do decide to waive any restrictive covenants, you could also use this waiver as consideration for incentivizing the employee to enter into a mutual separation agreement. Confidentiality. So employees will generally be bound by confidentiality obligations post-termination, but it's prudent for employers to remind employees of their confidentiality obligations or to have them enter into fresh confidentiality undertakings on termination of employment, depending if you want them to be more robust or if they're not particularly good in the employment contract in the first place, and also depending on the employee's role and seniority. Outplacement services. This is not particularly common in Asia Pacific in my experience, far more common in Europe. But you might want to consider whether you want to offer this to employees. So this is just assistance with them trying to get another job or career, and it can be part of the separation package. And it can be very helpful to employees if you provide that. And it can help with your reputation as well amongst the employees who are being made redundant. Two more points very quickly. Debriefing. So after a RIF exercise, it's always a good idea to have a debrief, either just internally or with your external legal team, and look at lessons learned. Are there matters for improvement or special points that should be noted? Are there particular cultural factors or legal requirements that the employer should bear in mind if there's a next time? Hopefully there won't be, but these things do happen. And consolidating all this information, as well as keeping a good record of all the relevant paperwork and communications, can be really valuable if there are future RIFs. And final point here from me, and last but not least, is the employer should have a strong strategy around managing employee relations. So risks of any scale can affect existing employees in numerous ways. Their job duties and compensation might be different. There might be feelings of negativity or insecurity. So it's important for you, the employer, to provide adequate support and reassurance to the remaining employees for the workplace to remain positive and productive. For example, employers could arrange for employees to have access to employee assistance programs, encourage open communication between managers and employees, communicate a positive outlook and company values to the employees, and provide reassurance, if possible, that there are no further planned RIFs for the time being. Now over to Leon. He's going to talk about some common risks in relation to RIFs.
Thank you, Kat. In this part, we will talk about the risks and consequences if a unilateral termination is regarded as a wrongful dismissal during legal proceedings. Wrongful dismissal may have different meanings in different jurisdictions. For example, an unlawful termination, unfair dismissal. In our case, it refers to the dismissal in breach of law. This chart presents the consequences for wrongful dismissal in various jurisdictions. You can see that reinstatement is the most widely recognized consequence, serving as a main punishment measures for wrongful dismissal in Indonesia, Korea, and Japan. Besides, compensation is also important as an alternative or combined consequence for illegal termination in Singapore, Taiwan, Hong Kong, and Australia. Let's look at the case in the PRC. So in the PRC, when an employee's unilateral termination is deemed as illegal, the employee is entitled to either having the employment reinstated or 2 times of the statutory severance pay. The employee may choose one of these 2 options at his or her own discretion. Furthermore, if the employment is finally reinstated, the employer needs to pay the same salary to the employee during the period of labor arbitration and the litigation. Next slide, thank you. Based on the risks we have just analyzed for wrongful dismissal, we now offer you some key takeaways. First, before reduction, determine the ultimate goal and work backwards. This requires thorough analysis of the whole company and the employment group. Second, ask yourself this question: what's a priority? Which one is more important? Maintaining good employee relations, speed, or minimizing overall cost? By answering this question, you will be clear and can focus on your ultimate needs. Then try to get the full picture from local HR and central headquarters to understand the current employment and the reduction situation in your area. Lastly, please bear in mind that it's inevitable to face litigation and industrial disruption in a large restructuring. Therefore, it's important to be aware of that and be fully prepared regarding the timeline and the budget. Hope all the advice will help you make an appropriate decision and minimize your risks regarding RIF. Next slide, thank you.
All right, well, I think we've timed this almost perfectly. I just had a couple of quick questions, and we've got about 4 minutes. So Kat, in 2 minutes or less, we know that often an employer might want to take into account underperformance or historical disciplinary issues when selecting who stays and who goes in a RIF. What guidance have you got for us on that point in the region?
Yeah, well, I think the first point is we can't confuse a redundancy exercise with a performance exercise. And I think sometimes that happens is that companies understandably think dealing with a performance improvement plan and terminating employees for performance reasons is quite tricky, and it's less personal if you do a redundancy. So sometimes clients come to us and say, look, these are poor performers, we want to get rid of them by way of redundancy. And that can be a bit messy if that starts to unravel. That said, if there is genuine redundancies there, so there is a requirement, a need to reduce, or there's just no longer a requirement for a certain number of employees to be doing certain work, and you're looking at selection, then of course when you're looking at selection you have to be thinking about objective and non-discriminatory ways of deciding on it. And one of these things could of course be appraisal scores. That's quite a normal thing for that to come in. Sometimes you have to bear in mind whether there's any disability that may affect their performance in some way, so you need to factor that in if any accommodations need to be made in that regard. But yeah, it's okay to have it as a criteria amongst your other objective criteria, but what you shouldn't do is try and disguise a performance termination by way of a redundancy, because that, as I say, quite often unravels.
Thanks, Kat. And Jana, over to you. I know you've done a lot of these RIFs across multiple jurisdictions. Just talk us through what the key difference is where an entity is exiting a jurisdiction rather than, or altogether, rather than just reducing the number of employees in that jurisdiction. What are the key things to consider?
Yeah, it's true. I have been the Grim Reaper of sorts for full country exits and corporate wind downs across multiple jurisdictions, many a time, unfortunately. Legally speaking, the economic criteria might be easier to establish, as Leon mentioned, right? Often shutting down is an explicit justification in the law because there's, of course, no more need for the employees. Practically speaking, things will look a little bit different, and it could be a little bit of a double-edged sword. There may be timing pressures if a full corporate wind down is contingent on reducing all of the headcount, or if it will require continued support from certain key employees. So I think we talked about that a little bit. You may not be able to exit a jurisdiction and get your corporate entity off the books until the last employee goes. And if that employee is uncooperative, that can be a problem. And equally, it may be hard to find the key employee that will stick it out through a long wind down procedure and knowing that they are exiting anyway. And sometimes money is an incentive enough. Budgets might be legitimately constrained, and so sometimes there is no money, but sometimes that in itself is an effective negotiation tool because money is on the table now when you approach the employee, and often companies will say money may not be available later, or if you drag your feet, or if you don't sign now, or if you threaten to sue, etc. So take what you have what we're offering now, and that can be very effective to actually get the numbers that you need.
Thanks, Jana. Well, we're at time. We have received a couple of questions in the chat box, and we will get back to people individually after the session to the extent that we haven't answered those things already. And just in conclusion, thank you everyone for joining us today. We hope you've got some takeaways from the session, and feel free to reach out to any of us afterwards if you've got any specific questions. And thanks to my co-presenters, Jana, Leon, and Kat. Have a great rest of the day.
Thanks. Bye, everyone.
Thank you.